Hello and welcome everyone to the webinar on Let Someone Else Buy Your Next Investment. Checkbook IRA LLC is your new best friend. Over the next hour, we're going to educate you on what Checkbook IRA LLCs are and how to use them for your investments. We're going to go through an introduction, talk about the advantages of a Checkbook IRA LLC, and we're going to talk about the cautions so that you understand how to use this new tool. We're going to talk about what we do to create a Checkbook IRA LLC, and then I'm going to turn our webinar over to three guests to go through how to invest with IRAs using the LLC, the legalities surrounding the LLC, and tax issues. Then we're going to wrap up with information on how to execute. Our special guests today are Michael McNair from IRA Services Trust Company. IRA has been with the trust company for many years, and one of the great things about Michael is that not only is he in charge of marketing for this company, but he also is in charge of customer service. And as any of you who have worked with us in the past understand, customer service is a big issue for us. So we're really thrilled that we have Michael as part of our panel. We also have David Adkins, General Counsel and co-founder of Integrated Wealth Counselor. David Adkins is an asset protection attorney. We lean into him for many different issues, and he's the attorney who has written the operating agreement for the Checkbook IRA LLC. So he is a wealth of information, and we're really happy to have him as well. And then those of you who have worked with your entity solution and Yes Business Solutions in the past know Warren Taro, who is our CPA, friend, and partner in the company, and a wealth of information on how to use your taxes to best advantage. So with those three people, you're going to learn a tremendous amount over the next hour, and we're very happy to have them on board. So let's get started with what is a Checkbook IRA LLC. Now, most of you are familiar with when IRAs first came out. A standard IRA account allowed you to put in a little bit of money each year and save it up. You could do some investing, and it would grow tax-free, and then you would pay taxes on it when you took it out. You had very limited choices for investing. So if you didn't happen to like the lineup of mutual funds that were presented, your only recourse was really to move your account to another custodian. The custodian really decided what was on offer, and you might phone up and say, gee, there's a really good chance to get into something over here, but he didn't have to listen to you. A little bit later on, Roth IRAs became very popular. You put in after-tax money and you take out the money free of tax later on, but you still had the same issues. The choices that were presented to you were determined by somebody else. You didn't get a chance to come over and say, you know, there's this guy doing really great real estate over here, and I'd like to get in on that. The custodian didn't have to listen to you and usually didn't. Then entered the self-directed IRA account. Now, this gave you a much broader range of investments that were available to you. Of course, that took off the shoulders of the custodian the need to do due diligence, because he wasn't responsible for determining whether or not the investment was a good investment. He just had to determine whether or not investing in it was in compliance with the IRS rules. So you could do things like real estate. You could invest in prom notes. You could invest in businesses. You could do all kinds of things as long as you stayed within the IRS guidelines. So the custodian would get a request, and the request would usually be on paper, because if you phoned him, he didn't really have to listen. He'd say, go here and sign this form. He'd get paperwork. He'd look at it. He'd ask for more paperwork. He'd see whether or not everything was in line, all the legal documents were lined up, and then fund your investment if it was in compliance. And funding would take less time or more time depending on the custodian, how much staff they have, what their workload was, whether or not they thought the paperwork was okay, etc. So you might get turnaround in a couple of weeks, or you might get turnaround in a couple of months. And by that time, whatever investment you wanted to go into might actually have been closed at that point. There were many of us who invested in small businesses, and we would listen on call after call after call where the person doing the raise was saying, you know, we're waiting for this IRA money, we're waiting for this IRA money, we should have closed 2 weeks ago, we're waiting for this IRA money. And in the end, what many of them decided to do was to move the people with IRA money out of the way and allow other investors with cash to come in, because they couldn't keep the raise open any longer. Most of us wanted to get on with earning money. So in that environment, while you had a much broader range of investments that you could make, the issue was getting the money in a timely fashion so that you could go into the things that you wanted to enter. So now enter the Checkbook IRA LLC. This is an LLC that is completely and wholly owned by your IRA. You have no ownership whatsoever in this LLC. The custodian funds the LLC from the IRA holder's account. So if you don't have money in your IRA account, you can't fund the LLC out of your pocket. It doesn't work that way. You don't own the LLC. The IRA owns the LLC, and the IRA is the entity that must fund it. You are then wholly responsible for ensuring that the investments that you make by writing checks out of this IRA account are in compliance. So remember, we said that in a self-directed IRA account, you're responsible for doing your own due diligence and ensuring that the investment is going to be a good one for you. Well, with a Checkbook IRA LLC, in addition to that, you are also responsible for ensuring that the investment is in compliance. And what that means is that you have to make sure that if you do not know whether or not you are abiding by the IRS rules, that you get in touch with your custodian and say, okay, I want to do this investment. It's a really great investment. I've checked it out. It's going to give me the returns I want, but I'm not sure if I can do it with these parties or what the implications are if I do. Now, as the manager of the LLC, you have checkbook control. If you're not the manager of the LLC, and in some cases you may not want to be, you may have been delegated checkbook control by the manager. So you're the guy who has the pen and the check, and you can write out your investment options as fast as you can. All you have to do is sign your name on the check and hand it in. So remember, you do your due diligence, and you make sure you're in compliance, and then you write the check, and you're in business as fast as you like. Now, there are some advantages and some disadvantages. Actually, not disadvantages. We're going to call them cautions because they're not disadvantages. They're just things you need to know. So you can do instant funding of your investments. There isn't any need for you to educate the custodian in each investment. It's your decision on whether or not this is a good investment for you. All you have to determine is whether or not it's in compliance. And another thing that you can do is you can actually partner up to IRAs inside of an LLC. Your spouse's IRA with your IRA, or your Roth and your traditional IRA, or combinations, so that you get all the money together for ease of investing. And there are some caveats in that we'll talk about later. Cautions are, you are responsible for knowing the rules, as we just said. You still have to do your due diligence, just like you do with any self-directed IRA. And you must supply investment valuation to your custodian every year so that they understand what the value of your total IRA is. They will take the valuation of the investments in your LLC, add it to whatever is still in your IRA account, and do a valuation. So you are responsible for doing that paperwork. If you're not good at paperwork, make sure for each investment that you give the paperwork to someone else who can track it and provide that valuation to the custodian at year end. How are we going to do this? Setting up the LLC for you is actually extremely easy. All you do is go to the website, www.yourentitysolution.com. You'll see a little picture of a checkbook over on the side, and you click on that, and it'll bring up the order form. Now, we're going to be changing our website, so the little checkbook picture may go away, but it'll be obvious where you have to go to get the order form for the Checkbook IRA LLC. We're going to contact your custodian to make sure that they will work with the LLC. If yes, then we're going to find out what their requirements are. If no, then we'll come back to you and give you the option of transferring your IRA to another custodian. And if you don't know another custodian, we have people that we can recommend. We're going to create a Nevada Series LLC with 3 cells, which will allow you to add additional money later on, and David's going to talk about that. And then we're going to send out the minute book to the custodian to sign the operating agreement and issue the certificate. Then we're going to submit your signed request for payment to the custodian to pay for the setup out of your IRA account. That's right. You do not pay for this out of your pocket. The IRA must pay for it. So we'll submit a request to your custodian who will pay us directly out of your IRA account. And while they're processing that, we're going to work with Washington Mutual to set up a money market account in Las Vegas so that when your money comes in, it will actually earn some interest while it's waiting for you to make an investment. Then you'll request your custodian to fund that account. And you're in business. That's all there is to it. So, having said all that, I'm going to turn the floor over to Michael to talk about investing with your LLC. Hi, Michael.
Hello, Wendy. Thank you very much for giving me this opportunity.
You're welcome. I know that our people are very interested in what you have to say. So let's start.
Okay. Well, before we get into some of the nuts and bolts regarding prohibited transactions and so on, I'd like to take just a moment to talk about the whole self-directed IRA industry, if you will, for just a moment. Self-directed IRAs have actually been around for a long time. Our company has been doing this since the early 1980s. So it's not something new, but what's interesting, of the something like $4 trillion that are currently invested through IRAs, only about 2% of that money is being invested in self-directed IRAs. So you can see that even though self-directed IRAs have been around a long time, not very many people are aware of them, and they can be an extremely powerful tool for investors. There are probably 15 to 20 self-directed IRA custodians, not quite as many as there are brokerage firms, banks, and mutual fund companies. So it isn't hard to find them. We are spread all over the country, but as I mentioned, there's only about 15 to 20. And if you were to Google self-directed IRA custodians, you would get, I'm sure, a pretty complete list by using the internet. Well, opening and funding a self-directed IRA also is a very straightforward process, and I just want to touch on that as well. When we get a call from a customer asking about opening a self-directed account, it's really a matter of simply filling out a few forms, an application, a beneficiary designation. We're going to ask for a driver's license or a passport to identify yourself, and then some instructions on how you're going to fund the account. Most people fund their account by transferring those funds from another custodian, a brokerage firm, a bank, a mutual fund company, or they may choose to roll over money from a 401k plan or other qualified employer-sponsored plan. Either of these are fine, and of course the old standard method is making a contribution to your IRA, which is another way of funding it. And as you may be aware, the contribution limits have been increased considerably over the last several years, so that you can actually make a significant contribution nowadays, which helps build the base of your self-directed account. Once you've funded the account, then of course we look for you to instruct us on what you're going to invest in, and if your choice is to invest in a solo or an LLC, a checkbook LLC, then that's what we will do for you. The requirements for that are pretty basic. We want to see your operating agreement. We want to see your tax identification number. And we want you to sign a special agreement, which I will discuss a little bit further later on in the discussion. So now you've got your checkbook IRA and you're ready to go. One of the things that Wendy will talk to you about, your operating agreement, will undoubtedly address. And we will make sure you know that there are certain transactions that we're not too fond of. And actually, it's not our choice. It's really the IRS guidelines that determine whether or not you are able to enter into various transactions. So there's something called prohibited transactions. And what that means is that if you enter into a transaction with a disqualified person or entity, then the IRS could deem the IRA null and void and require that we distribute the entire contents of that IRA to you personally, which could have significant tax consequences. So this is pretty serious business. The disqualified parties, or the people with whom you do not want to enter into a transaction, is primarily yourself, but also your immediate ascendants and descendants, meaning that You do not want to enter into a transaction with your parents or your children, your grandparents, or your spouse.
Now, Michael, what about step-parents or stepchildren? How do they qualify?
Stepchildren are not disqualified unless they've been adopted. Adopted children are disqualified. Parents of your spouse, I believe, are considered okay. And of course, it's really kind of interesting how the IRS made these decisions. But brothers and sisters and aunts and uncles are allowed, are not considered disqualified, and any other distant relatives. So there are people with whom you can go into business with or enter into transactions with, but you also just want to make awfully sure before you enter into that transaction.
So I guess that this is a great excuse not to get married, right? You can partner with whoever it is that you're living with.
Or you might look at it as though it's a good opportunity to get married so you don't go into business with your spouse. It depends on how yeah, so this is a really important thing, and that's one of the problems we run into as a custodian. When we're acting as the intermediary, if you will, for each of your transactions, we can sort of verify that. When you're operating your own your own checkbook IRA, which gives you absolute control, it also gives you the opportunity to make those kinds of mistakes without our knowledge. And sometimes I will see promissory notes that have been entered into between the checkbook IRA and the individual, and the borrower, if you will, has the same last name. Well, obviously that sends up a red flag, and I start asking questions about who is this person and so on and so forth. But a lot of times we wouldn't be aware of that. And what you don't want to have happen, of course, is to have the IRS come in and ask a few questions and find out that you've entered into a prohibited transaction, and then you pay the consequences.
Right. I guess this raises a really interesting point, that if you, let's say that you and the person you're living with have checkbook IRA LLCs and you've gone into a deal together, what happens if you subsequently get married?
Well, that's a good question, actually, and I'm not sure the answer to that question. I would suspect that you might have to, well, obviously the thing to do is consult an attorney, and David may have some input on that. I've never heard of that situation occurring.
So the answer is, before you get married, get advice.
Yes, exactly.
Okay. So what sorts of things are prohibited transactions? I know that I can't buy life insurance.
Okay. Well, yeah, there's certain investments that are sort of prohibited, and that would be one of them. Any sort of transaction involving, say, a loan to a disqualified person. There's a tendency to want to loan money to a child or to a parent or to even to your spouse, for that matter. And because people have money in their IRA, they think, oh, I know, I can use my IRA money for this, and I can loan money out. There's a couple things to be aware of. One, you can't loan money to those disqualified people. That includes, by the way, an entity, a business in which you or a disqualified person has a controlling interest. So if your son is trying to start up a business and he needs some money, you can loan it to him, but not through your IRA. That would be considered a prohibited transaction.
And how much is a controlling interest?
Well, generally it's thought to be 51% or anything over 50%. But if the person, if the disqualified person, if you will, is making day-to-day decisions and essentially running the business, it's subject to interpretation. And again, you just want to be awfully careful and seek legal advice if there's any doubt at all.
Okay.
Yeah. The other thing I want to mention about loaning money, because it is a popular thing for people to do, is that the IRS is interest is in ensuring that the IRA is benefiting from their investments. The idea of the IRA is to enhance the value of that IRA over time. Of course, the IRS's interest is as the IRA grows, and particularly if it's a traditional IRA, they're going to get taxed on that money down the road. So they don't want to see you lending money to anybody, disqualified or qualified parties, at a rate of 2%. They want to make sure that whatever you're doing with that investment, you're making a reasonable return. Now, that's not to say you can't make an investment that does poorly, but if you structure a deal like a promissory note that you're paying under market or charging under market interest rates, that could come up and bite you in the long run.
Okay. We also get people who say, well, can my IRA buy a property, and let's say I rent the property out as a vacation home to my sister or brother. Can I then stay in it from time to time?
Not without serious consequences. No, again, that would fall into the category of a prohibited transaction and self-dealing, because you're getting a benefit. The IRA holder is not to gain any benefit as a result of their investments through their IRA. So the most extreme case I've ever heard of this type of transaction is one in which a gentleman owned a lot, an empty lot, and was in the area, and to avoid paying parking, parked on the lot that he owned through his IRA, and was told that that was a prohibited transaction. Now, don't ask me how in the world anybody found out about that. And of course, that's one of the issues that people always raise with us as well, is that how is the IRS going to find out? My answer is, I don't know how they may find out, but if they do, you run the risk of serious penalties.
Maybe they can read your mind. I don't know. The things that they find out always astound me.
Yeah.
Now, Michael, I know that we can't invest in collectibles, which just breaks my heart because I love wines, and that's not on a list of things that I can do. But someone did ask whether or not you can invest in diamonds.
Yes, investing in any sort of precious metals, and I don't know if diamonds actually falls under precious metals, but if the custodian will hold the investment, that is to say, actually take possession of it, then you may invest in gold, silver, anything that's on the market. There's a whole commodities futures market that many of our investors get involved with, and sometimes it requires taking possession, although usually it does not. But there are custodians, and we are not one of them, who will actually take possession and vault the precious metals that you may choose to invest in.
Okay, so they would have to put them somewhere where they're protected with a custodian or a bank, perhaps, with the account in the name of the IRA. Is that correct?
That is absolutely correct.
Okay, great. Any other things that we need to be aware of with regard to prohibited transactions or prohibited parties or disqualified parties?
Well, the idea of partnering or investing along with a disqualified party into something comes up also, and of course that is perfectly okay. That is to say that you and your spouse may in fact invest in the same LLC, the same checkbook LLC. You might partner with anybody investing in the same thing. It's just what makes it prohibited is that there's actually a transaction between the two parties. So an individual, their IRA, their spouse's IRA, all of which are treated as separate entities, can all invest in the same investment.
Which brings up an interesting point. If someone is investing in, let's say, rental real estate, and they decide to get a little rental property, they use their IRA, their checkbook IRA, to write the check for the down payment. They can then get a non-recourse loan as a mortgage on the property. Is that correct?
That is also correct. And let me just mention that most of the self-directed custodians are familiar with the fact that there's probably only a couple of banks out there that will make these non-recourse loans specifically for IRAs. They're mentioned on our website. And of course, you can get private funding for something like that, which is fine as long as the lender understands that it must be a non-recourse loan. So whether you raise private money or go to one of these one or two banks that offer it, either is fine, and it is done all the time. It's quite a popular way. And even though the lender may charge a little bit of a premium and also require a higher down payment than you might otherwise provide, because now the point being is they can't go after the IRA or after you personally if for some reason you're unable to make the loan payments. So they're going to have a little tighter requirements, and one of them is they're going to probably require 30 or 40% down, and they're going to charge you probably a point higher than what the normal interest rates are for that kind of loan.
Right, and there is a lender that our listeners can get to at www.myiralender.com, which actually has your entity solution on its webpage.
There you go. That's North American Savings Bank, actually out of Kansas.
Right, and they do it as well. So those two, and I can't remember the bank for my IRA lender off the top of my head, but it is on their website as well. So those are the two that we're familiar with.
Is that the one in South Dakota by any chance?
Yes, I think it is.
I think that's, yeah, it's on our website as well, and I can't remember. It's something Federal Savings.
Well, our listeners will find it if they go to the website. So, great. Okay, so let's move on to adding contributions after the LLC is funded, because this is a big thing both for the listener and for the custodian.
That's right. Absolutely. In fact, I mentioned earlier that we have an LLC agreement for private or single-member LLC specifically dealing with that issue. And what we ask for is an opinion letter from an attorney regarding subsequent investments. This whole idea goes back to a legal case, a Swanson case that dealt with this, and they determined that in that particular case that making an investment in an LLC that was being formed at the time it was being funded allowed the IRA holder to have control of that business as a manager. And David will speak to this in more detail, I'm sure. But the idea being is that once the LLC has been formed and is operating, whether or not a subsequent investment, say a contribution from a future year, or you want to roll money in for an additional investment, might be considered a prohibited transaction. And so what we look for is that the operating agreement, and that you understand as the manager and the IRA holder, that you understand that there are some people who interpret that as a prohibited transaction, or who might interpret that as a prohibited transaction. So it's important that this be discussed up front, and that if you think that you're going to want to make subsequent investments or fund the IRA after its formation, that you discuss this with your entity solution or with an attorney to make sure that there's provision for that.
That's great, and David will be speaking to that. We've discussed this long and hard,
sure
and set up a system where we believe that this will be to the best advantage of our clients and not be prohibited. So thank you for bringing that up.
Yeah, and from what I've seen, I think it's a wonderful solution to that issue too, by the way.
Thank you. I'm sure that David is greatly relieved. We certainly put him through the ringer on this. Okay, so now, Michael, as a custodian, what do you need when you've got a client who has a checkbook IRA LLC? What do you really need to make your life easier and make sure that you can help the client as much as possible?
Well, I tell you, from your earlier comments, Wendy, I really appreciate the things that you mentioned. A lot of people want to get into this by getting online and finding an operating agreement or something they can throw together for a few bucks, and then open their LLC and go to work making investments on their own. This really makes us very nervous because we don't suspect that they've received adequate legal advice, and that they may not be prepared for some of these issues regarding subsequent investments and prohibited transactions. So we've created a little one-page agreement detailing some of these things, making sure that you understand them, because you see, we have no insight into the day-to-day operation of this business, and we have no desire to do so. But we want to make sure that we've cautioned you about the possibilities of prohibited transactions and subsequent investments. The other thing is that we also state in this agreement that you will provide us with an annual valuation of the LLC. And you wouldn't believe the documents that we receive from people, on the back of a napkin, literally. And so being able to keep accurate records is very, very important. Making sure that you're keeping your LLC transactions and activity and accounts completely and totally separate from your personal, and that you can, at least once a year, detail the assets that are held in that LLC. It may only be one, but you may be lending out 10, you may have 10 promissory notes, you may have all sorts of things in that LLC, that you can list those and provide documentation as to their value at some point in time, preferably at the end of the calendar year. And that's pretty much what we need, but it's sometimes very hard to get it.
Okay. Well, we'll try to help you if it's our client. Last thing I have a question for, and then I've got a couple of points, and we'll move on to David. People have been asking how you retrieve money from an investment that's been done through the Checkbook IRA LLC, and what we've been telling them is that when you sell the investment, the money goes back into the IRA LLC, and then those funds need to be transferred back to the custodian before you take money out. Is that correct, Michael?
Yes, it is correct. And the idea is that we want to, because we're required and responsible to the IRS for reporting any transactions that involve a distribution, and so to the individual. So in order to make sure that there's an adequate audit trail, we want to make sure then that any money that the IRA holder may want personally in the way of a distribution comes to us from the LLC, just as it would from any investment that any of our clients who don't have checkbook IRA or LLCs would do. We want the money to come to us, and then we would issue you a check or wire the funds to your personal account. And then, of course, we would be reporting that to the IRS in the form of a 1099-R.
Okay, great. So just want to make sure that everybody's got the point that we started out with. You need a self-directed IRA account to link to your Checkbook IRA LLC. If you didn't get that point at the beginning when Michael was talking, please jot it down somewhere. If you have a normal IRA that is not self-directed, you must roll that account into a self-directed account before that money can then be put into a Checkbook IRA LLC. You cannot link a normal IRA account to a Checkbook IRA LLC. So thank you for bringing that up, Michael. Okay, so we're going to move on at this point. Oh, and I'm going to make one more point before we go. Sole 401k accounts, we can do checkbook LLCs for those as well. Is that correct, Michael?
Absolutely, that is correct. And there are not as many custodians that administer those, but there are a number of them that do. And if anybody needs the name of some of those, I'd be happy to provide them with
Okay,
that.
great. Thank you. Okay, David, we're moving on to you and the legalities surrounding the Checkbook IRA LLC.
Okay. Well, thank you, Wendy. Before we transition, though, I had one question for Michael. Michael, what if your Checkbook LLC owns real property? I have a Checkbook LLC that owns real property, and I want to make some repairs to the property. Let's say I need a new roof, and I'd love to use my Visa card to get some miles, and then I'll just have my Checkbook LLC pay the bill. Is that something that I want to do, or is that something I want to avoid?
I think that's something you want to avoid. I would suggest you get a credit card in the name of your LLC.
Okay.
As a solution to that issue. But yeah, you really do want to be careful about repairs, and anything that's being done should be paid by the LLC in one form or another.
Okay, so I want to avoid being involved in that transaction in any form.
That's correct.
Okay, good. Well, Michael, you're a wealth of information. You brought up a lot of good points, and one of the points that you brought up was that we really need to avoid a prohibited transaction, and focusing on the transaction side of that, the IRS has said that partnering along with another disqualified person in a newly formed LLC or corporation is not a transaction with that person. You're going in side by side. And that's one of the concerns we have for future funding. Or if I have a single member LLC and I want to decide to bring my wife in later on, well, we've got an issue if we're using the same LLC, and I think we've addressed that with the use of the Series LLC. I believe that we have a good solution to that issue. Well, what is a Series LLC? I think there's a lot of confusion surrounding just what kind of entity this is. And a Series LLC is really nothing more than a typical LLC with one added feature, and that is through the inclusion of some additional language in the Articles of Organization and the operating agreement. The members and the managers now have an option to create one or more compartments or series within the LLC. The Series LLC, to be effective, must be established in one of the 7 states that allow for the Series LLC that have adopted specific legislation. And those are Delaware, Illinois, Iowa, Nevada, Oklahoma, Tennessee, and Utah. We like Nevada for a number of reasons. Number one, it's what we call a sole remedy state for charging order protection. And Nevada does not require registration of each series with the state. So the members and managers are free to establish an unlimited number of series, and it's a very simple process. The issue has been raised in the past that, well, what about states that don't recognize the Series LLC? Can I use my Series LLC in those states? What if I live in California? Well, the Series LLC is going to be recognized in all 50 states. The issue is that for property held within a jurisdiction that does not recognize or has not adopted that language, there's a good likelihood that the courts will disregard the internal division between the series. Well, we're not really using the Series LLC for the purpose of separating assets between series. How we use the LLC with regard to the checkbook IRA is that we use it to separate funding. So, for example, when you create your checkbook checkbook LLC, the owner will instruct his or her custodian to fund an initial series into this LLC, and no other interest in that series will be granted. So when it comes time for an additional funding or a partnership, the series, the funds remaining in that series can now be transferred back to the custodian and with instructions to set up a brand new series between the partners or with the additionally funded amounts. By this, we really avoid that possibility that any additional funding would be deemed to be a transaction in that existing LLC.
So it looks like we have a good solid workaround for Michael's initial concern.
Yes, I believe we do. The only other option would be to create a new LLC each time that you desire to fund your LLC, and that would be costly and cumbersome.
It would, because in the case of many of our listeners, they probably have investments outstanding at the time that they set up the Checkbook IRA LLC. When those investments come back and are paid back into their self-directed IRA, they may want to move that money then into the Checkbook IRA LLC to add to what they already have, and so having to set up a new LLC every time would be incredibly cumbersome.
Right, precisely. And why we can do this is that the IRS recognizes each series as a separate entity. In fact, the IRS will issue, upon request, a taxpayer identification number to each series, series by series. So a series LLC might have 100 separate series and 100 EINs.
Great. Now, David, we have listeners who are in California, and I know you and I have been back and forth many times on this issue of the Franchise Tax Board wanting to have outside LLCs registered in California if the manager is a California resident. And we'd also discussed the fact that in the case of the Nevada Series LLC for Checkbook IRA control, that we could actually have an out-of-state manager who delegates checkbook control to the holder of the IRA. Is that correct?
That is correct. And I don't think we're engaging in any subterfuge because California takes the position that its residents are subject to the minimum franchise tax if they're actively managing even an out-of-state LLC. We don't like to see any investments in your checkbook IRA other than passive investments, notes receivable, stocks and cash, and the like. If the owner is investing IRA funds through the checkbook LLC into actively managed properties, we recommend that the checkbook IRA form a separate LLC, say a California LLC, to hold those properties. That way, the California taxpayer is not engaging in any active management of a business or trade through the checkbook IRA. I guess in essence, the subsidiary California LLC that would hold the property would be subject to the franchise tax, and the checkbook LLC would register that subsidiary LLC with the Franchise Tax Board.
All right, and I think our listeners are very used to doing that for properties that they own around the country if they are a California resident. Okay, so that's good. We have a good solution for the California people as well. I can hear them cheering in the background.
I think it works well, and with regard to the management of the checkbook IRA, the reason we do that is just to keep the IRA owners' names off the public record. We take the position that the IRA owner can be appointed a president or given authority within the LLC over the cash asset and the decision-making process. We don't think that the owner is engaging in any business in California by doing so. So we're comfortable with assigning or delegating that authority and taking the role as manager.
Okay, great.
I don't know if that if that was a little convoluted, but it works.
Okay. So now, if we can move on, what happens if we have spouses who want to use the same checkbook IRA LLC? What's different from the normal way we would set this up?
Well, it's not a problem at all. The operating agreement that we use for the checkbook LLC provides for the inclusion of any number of partners. So it has the partnership language. It can be used to establish a single-member LLC or a partnership with a spouse or other disqualified person. Again, if the partners are going into the newly funded, newly formed LLC or series, or it can be used to partner with a non-disqualified person.
Okay. And they just need to bear in mind what happens with the investments when you are partnering in that checkbook IRA LLC.
Well, that's a good point. Say a husband and wife have IRAs, his $60,000, hers $40,000. They would invest simultaneously into the series of the LLC in exchange for proportionate shares, 60%, 40%. The manager or managers of the LLC, or let's say husband and wife as co-vice presidents of the LLC, if they're operating as officers of the LLC, would have the control over the functions of the LLC, its investments. But any income into the LLC, any gains, would be realized by the LLC and eventually distributed in proportion to the owner's shares. So eventually when the funds are distributed back to the custodian, and it's important to point out that the custodian is the owner of the LLC, is the member. So when the funds are distributed back to IRA Services, they would be funded into his IRA 60%, her IRA 40%.
Okay, great. So if we're looking at spouses who might want to do their own investments and join together them in those investments where they are partnering, they may want to form a separate LLC owned and have their interest owned by their respective checkbook IRA LLCs, and that way they can partner on certain investments and do their own investments separately as well.
Absolutely.
Okay. Is it time to move on?
I guess we've covered most of the issues.
Okay. So we talked a little bit about rental real estate and how the IRA should hold it, and that is in an LLC outside of the checkbook IRA LLC, but owned by it. And you would follow the normal rules for rental property, I believe. So if you're buying a property in Idaho, you'd set up your LLC in Idaho and have it owned by your checkbook IRA LLC. Is that correct, David?
I think that's my understanding of really the best solution. Any of the actively managed properties, I would advise holding within an LLC, either organized within the location, the state in which the properties are located, or if properties are located in several states, organize a separate LLC in Nevada, which is owned by the checkbook LLC, and have that LLC hold properties within various states. There's not a problem with registering a series in California if all of the California property are held within that series. California takes the position that is an LLC.
Okay, but we're advising them to keep their property out of the series.
Out of the checkbook LLC. Yes.
Right. Okay. What about promissory notes or shares in a small business or stocks, bonds, trading accounts, those sorts of things, where you probably are unlikely to get sued?
Yeah, those kinds of cold assets, those can be held directly in the checkbook LLC. So if a checkbook LLC is initially funded by an individual or husband and wife into, let's call it a Series A, I have no problem with that series holding various types of cold assets, cash, stocks, notes receivable, shares in small businesses, as long as there's no active management conducted within that series. If there's actively managed property, if the checkbook LLC is to actively manage the property, then that should be held in a subsidiary LLC. But otherwise, really, there's no problem with combining all of those assets within the same series.
Okay, great. And as we said, when you need to do additional contributions, you would move everything from Series A back to your custodian. Michael, for example, he would add in any additional contributions and then fund everything back into Series B.
That's correct.
Okay, good stuff. Sounds like a lot of paperwork, but I know that it's actually a lot simpler than it seems.
You know, it does sound like a lot, but it's really a pretty simple process. And I know, talking with Michael, IRA Services is completely on board, and it's not an expensive or a time-consuming process.
Great. Okay, any last words, David, before we move on to Warren?
No, I think we've covered most of what we need to.
Okay, great. Thank you.
Thank you.
Okay, Warren, let's talk about taxes. I know that this is a great topic for our listeners. And to start that off, what about the dreaded UBIT?
Yeah, great. So let's save the tax side for last. Okay. So UBIT's probably the thing we get the most questions about of anything. And first, what UBIT stands for is really unrelated business income tax. And so we think of the name, it helps us figure out what it is. And so what happened is Congress decided that they wanted to keep a level playing field. They wanted businesses to play all from the same place. And if there was a business that was owned by tax-exempt entities, such as IRAs or other not-for-profit type companies or whatever, then that would give that business an unfair advantage over its competitors, because it doesn't need to make as much in profits because its owners aren't having to pay taxes on the profits. So Congress just thought that this was completely unfair and decided to create an unrelated business income tax, which makes those tax-exempt and not-for-profit organizations have to pay taxes on income they earned from things that they weren't granted their tax-exempt status to do. So, for example, hospitals. If there's a not-for-profit hospital operating, their purpose is to heal people and make them better and that sort of stuff. And that's all well and good, but the gift shop downstairs doesn't serve that purpose. So income that gift shop would earn would be subject to the unrelated business income tax because it's unrelated to that.
You know, Warren, we live in Nevada, and that's just given me a whole new idea for funding hospitals through casinos. So I guess that would result in a UBIT, wouldn't it?
Right. Well, and it's a whole new play on gambling with your life.
That's true.
But and the cheats wouldn't have to be taken that far away. Anyways, so how does that work for IRAs? Well, if an IRA owns a business, an active business, a business, then that IRA is going to have to pay taxes on the profits that flows through from that business, just again to keep everything fair. So if the IRA were to invest in an LLC that's out doing business, let's say there's a pizza parlor that we think would be an awesome investment. They're just making tons of money everywhere. So they're opening a new location, and boy, I want to take part in that, so I'm going to have my IRA invest in the LLC. It's going to get a 10% ownership of that LLC that owns that particular location of that restaurant. Well, that's a business, so when that restaurant turns a profit and that 10% of that profit comes back to my IRA has to report and pay taxes on that money.
Now, Warren, what happens when I invest in IBM or General Motors? What's the difference between that and my pizza parlor?
Well, if you invest in a C corporation, which is what we do normally when we don't have a self-directed IRA, if we're really investing in mutual funds or stocks, that's what we're really buying is shares of a C corporation. C corporations have to pay taxes themselves at the corporate level. So just because you're a not-for-profit or a tax-exempt entity that owns that part of that corporation, you're still not avoiding taxes because the C corporation has to pay the taxes on it, and so that keeps that playing field fair for everybody else.
Okay, so somebody has to pay the piper.
Right, and so if we just keep the basic rule in mind, it kind of helps us understand. I hate to say that there's some logic behind tax, but every once in a while, if we understand the principle, we kind of know where we're supposed to go. Now, just because a particular investment might incur UBIT doesn't mean we shouldn't do it necessarily. You still want to look at it and consider it. I mean, if you think about it, if you were to do the same investment outside of your IRA, if you had money just in your wealth account or somewhere else laying around, you could use that money and make that investment, and you're still going to pay taxes. So we're not worse off by using IRA money. It's just something we need to know when we go into it, that there's that element to it. Now, the weird part, so that was the logic part, the part that we can kind of figure out what makes sense. The part that I haven't been able to make sense about UBIT is in real estate. And on the real estate side, if you own rental real estate and you leverage that, so you finance that real estate through your IRA, then the portion that's financed is going to be subject to UBIT. Now, that doesn't make sense with the level playing field stuff, but I don't know. That's where I give up and just say this is what the rule says. So let's say you were to buy a rental property, and a lot of the times you're going to need 30, 40% down, something like that, and then you're going to finance the remainder. So that means we finance, 60 or 70% of that purchase of that property. That 60 to 70%, as we get income from that property, is going to be subject to UBIT. So if we made $10,000, then $6,000 or $7,000 of that is going to be subject to UBIT. The amount that was associated with your down payment is not. Now, most of the time, this just really doesn't matter because, as most of us know, we're not making a profit generally from rental real estate. We have depreciation, and that offsets it, and we get to take all the normal expenses you would take otherwise, just as if you had the property outside. So we get all of those same expenses, and most of the time, there's not a profit. There might be positive cash flow, hopefully there is, but because of depreciation, there's not a profit, so that doesn't become an issue. When it does become an issue, however, though, is when you sell the property. So if we have a capital gain when we sell the property and we still have that property financed, that's where we look back and say, okay, now a portion of that is going to be subject to tax.
Ouch.
Again, it would have been if you didn't buy it in the IRA, so we're still probably better off. It's just keep that in the back of your mind.
Okay, well in the back of your mind.
Well in the back. It's just another thing in your due diligence. Is this a good investment? Okay, well, I'm not taking into account that I'm not paying taxes on it. That shouldn't. We should use the same calculation as if we were, and then we'd come out just fine thinking that way.
Well, you made a comment that was interesting. You said if it's still financed, what happens if you've been holding this in your IRA for 15 years and the mortgage has been paid off? What happens then?
Well, so long as the mortgage has been paid off, and there's a little bit of difference here. The safe harbor is to say as long as it's been paid off for 12 months. There's other people that have the opinion that so long as the mortgage was paid off in a different tax year than the year you sold it, you're going to be okay, and it won't be subject to UBIT. So the percentage that we're going to figure in UBIT is the percentage that's still financed. So yeah, even if it's not 100% paid off, maybe you've paid it down some, then those percentages change a little bit.
Okay, so here's my scheme. We go to Mexico, we buy this wonderful vacation property in our Roth IRA, and then distribute it out when I'm 65, 70, or young enough to still get there and enjoy it. So as long as I have no mortgage on it or have not had a mortgage on it for at least 12 months, then this is a good deal.
Well, distributing it out isn't going to, I mean, we would theoretically distribute it out with the mortgage in place. Might have to get the lender to cooperate with that. But then it would just be a distribution, and we're not looking at UBIT or anything on that. It's a taxable distribution coming out. Do you know if it was a Roth IRA, it could be tax-free distribution. And we see people do this, not necessarily even with a house in Mexico, but a house they want to do as a retirement home someday. And let's say you're in your 30s or 40s, and there's this great house in some city that you really want to retire to, and you know that's what you want to do, and your IRA buys that house and uses it as a rental property for all of those years. And when you're ready to retire and move into it, you distribute the property out to yourself. You take the tax hit as a distribution, but you sell your personal residence. And if you're married, as you know, with your personal residence, you can exclude up to $500,000 of gain. So we sell our personal residence basically tax-free, and then we take that money to pay the taxes on the distribution from the IRA.
Good strategy. Okay, we need to move on. We talked a little bit about making distributions from your Checkbook IRA LLC, and I'm assuming that when you have to take mandatory distributions, it's the same thing.
Absolutely. Now, mandatory distributions. First of all, if you have a Roth IRA, there is no such thing as a mandatory distribution. It's another nice thing about Roth IRAs. But if you have a traditional IRA, you're required to start taking distributions. Well, you're absolutely required the year after the year you turn 70 and a half. I just love the way they word things. It's the year after the year that you turn 70 and a half. Now, you really probably should consider taking it the year you turn 70 and a half, but you're allowed to wait one more year. If you wait one more year, you kind of have to take a double distribution. You have to take a distribution kind of for both years, basically. But you're still okay. And that distribution is going to be based on a percentage of what your value of your IRAs are. And this would be the value of all of your IRAs together. You might have several of them or other retirement vehicles out there. So all of these things, we need to know the total. Then there's a percentage that the government gives us to use. They calculate this for us based on how long they expect you to live and who your beneficiary might be. If there's if you have a beneficiary named, how long they're planning on living, or how long the government's planning on letting them live. And
I didn't hear
we
that.
come up with a number every year that we.
Okay, so they get their amount that they have to distribute, and we said no writing checks to yourself.
Right. It would be best, absolutely best, for you to use money. You might have money in other IRAs first that you could distribute that out and leave your checkbook IRA alone. It doesn't matter which one we take it from as long as it's that amount. But if the money's coming from the checkbook IRA, the best thing is to transfer the money back or write a check back to your custodian and have the custodian do the distribution, because we want to make sure all the paperwork is done correctly.
Okay.
And they might as well, they're getting paid for it, so they might as well do all that for you.
And if I listen to Michael, they're not getting paid very much.
There you go.
So it's a bargain.
We
There you go.
Any of it, though.
Well, I'd like this is Dave, and I think it's an important point. You've got to keep in mind that the custodian owns the LLC, is the member of the LLC. So the LLC has no business distributing any money to the IRA owner. It's a very important point.
Good point. Okay, Warren, what happens if I mess up and I use money to buy a wine collection?
Okay, so there's two kinds of messing up, really, that we can think of. There's the messing up, like you said, buying a collectible, which is one of the, and I only know of the two things we're not allowed to invest in, and that's collectibles and life insurance contracts. So if we were to do one of those things, and life insurance contracts is one of those where you buy somebody else's life insurance policy from them and gamble that they're going to die soon so that you get paid off. So I guess the IRS or Congress feels that that's kind of morbid and doesn't want you to play with that. But those are the two things that I know of. And if you were to do one of those two things, we would deem whatever investment you made as a distribution. So if you were to buy $10,000 worth of rare champagne, that $10,000 would become a distribution to you and be subject to tax and, depending upon your age, penalties. And so be it. It's done. We want to make sure, again, the custodian understands we've done this wrong, so they get the proper paperwork issued. You're going to get a 1099 for this, and we want to make sure it's coded correctly.
Okay, so we send them their split on the champagne, and they send us the paperwork.
Exactly. I don't know if will custodians work in barter, but anyway.
Absolutely. Absolutely.
Okay, so if we mess up, there's a chance to retrieve it without having blown our complete IRA. What happens, though, in the instance where I'm partnering with a disqualified partner?
Right. Now, if you can really blow it, and you're investing with a disqualified partner, or really making one of those, mean, awful-sounding prohibited transactions, that's a little more severe. And really, I'm taking a step back from what I've said before, but there is an intermediate step that doesn't blow everything up entirely, and that's if you correct it right away before anybody notices, and you pay a 15% penalty tax. It seems that might solve the issue, but if it's not corrected in the same year that it happens, then we're in trouble.
Okay.
And the trouble, basically, let's put it that the IRS would take away your IRA status in that LLC or that account and say, you know what, this is no longer an IRA, it's just a trust, and you've made a distribution of whatever the value in that IRA is, and it's taxable, and again, dependent upon your age, subject to penalties.
Okay, so that's pretty severe.
It's pretty severe.
Okay. So the bottom line is, if you are not absolutely sure about what you're doing, talk to your custodian first, because disqualified partnering is much more severe than just buying a collectible. Okay, any last words, Warren?
Probably a lot more common than buying a collectible.
Right. Any last words?
No.
Okay, so we're going to wrap up and tell our listeners how they can get moving. So you've learned the rules regarding prohibited transactions and disqualified parties. We've talked about this throughout this presentation, so you should know them by now. And if you don't, again, either talk to your custodian or come back and we'll reiterate them, or you can listen to this presentation again. Make sure that you do your own due diligence regarding the investments that you choose. Your custodian is not responsible for your poor choices. All the custodian is responsible for is to educate you on what's a prohibited transaction and a disqualified party. That's it. And do your bookkeeping and keep track of your paperwork. You will have to report the value of your investments back to your custodian every year. You must do that. So if you're very poor at bookkeeping, and I know a lot of us are, hire somebody to do this for you. It's not difficult. It just needs to be done. And when you're ready, go to www.yourentitysolution.com, click on the link to the Checkbook IRA LLC, fill out the order form, and fax it in, and it's that easy. We will talk to your custodian to make sure that they can work with this venue, and if there are any issues, we will get back to you. You don't have to do much more than just fill out the order form and send it in. And then when everything is in place, you request that your custodian fund the bank account that is attached to the LLC. And as we said, if you have a traditional IRA, ask us for referrals to custodians that we trust. You must have a self-directed IRA in order to have a Checkbook IRA LLC. So you can call us, or you can go to admin@yourentitysolution.com and send us an email message. And as we said, information on how to get to our special guests, if you would like to speak to Michael McNair of IRA Services Trust Company, his information is on the screen in front of you, or if you would like to speak to David Adkins, our attorney, or to Warren about taxes, you can call their offices. Their numbers are on the screen, or you can send email, and they'll be happy to get back to you. So to all of our listeners, thank you very much for listening, and to our guests, thank you very much for participating. I really appreciate it.
You're very welcome, Wendy. Thank you. Thank you for having me on.
Yes, thank you, Wendy. It was a pleasure.
Thank you, everyone, and goodbye.